Justice Anderson, are you connected or are you? Great. Thank you, Judge.
I think it is the appointed hour. Madam Deputy Registrar, would you please call the proceedings?
Indeed, the appointed hour. Thank you, Judge. Caribbean Court of Justice, Appellate Jurisdiction on appeal from the Court of Appeal of Belize, judgment delivery in BZCR number 1 of 20. Mr. Justice Barrow.
Good day to all.
Mr. Justice Burgess.
Good morning, Council.
And Mr. Justice Jamadar.
Yes, good day to everyone.
May we have the appearances, please? Thank you.
Good afternoon, members of the panel. Rajiv Prasad. I appear on behalf of Mr. Nevis Betancourt, the appellant in this matter. I am leading Ms. Karuna Besram Singh, and I am instructed by Ms. Sheena Pitts. I do apologize for Ms. Pitts' absence this afternoon. It is unavoidable, please, my lords.
Thank you.
Sherilyn Vidal, Senior Counsel, appearing on behalf of the respondent, Crown, and I too apologize. I am appearing in this matter with Mrs. Jacqueline Cheeseman. She is unable to join at this time.
Thank you, Counsel. Well, thank you for your appearances. I'm happy to report that we have considered and reached a decision in this matter, and also that my brother Justice Barrow wrote the lead judgment in this case, and I would ask him please to read a summary of the judgment of the court in this matter. Justice Barrow?
Thank you, President. On 27 July 2017, Jose Castellanos was shot inside a restaurant in Santa Elena Town, Cayo District. Nevis Betancourt, the appellant, was subsequently indicted and tried for murder. He was convicted and sentenced to 20 years imprisonment. The Court of Appeal dismissed the appeal and affirmed the conviction for the offense of murder. The appellant appealed to the CCJ on the ground that the Court of Appeal erred in upholding the trial judge's rejection of the defense of self-defense. The trial judge accepted the case for the prosecution, which was that the appellant entered the restaurant, shot the deceased twice before the deceased chopped him with a machete. The appellant continued shooting at the deceased, who exited the restaurant and thereafter died. At trial, the appellant gave evidence that the deceased chopped him unprovoked. He thereafter pulled his licensed firearm and shot the deceased in self-defense. The trial judge rejected this evidence as it was inconsistent with the rest of the evidence of eyewitnesses, which was corroborated by forensic evidence. At the CCJ, the case turned mainly on the submission by the appellant that after rejecting the defendant's evidence, the trial judge had a duty to apply the principles of self-defense to a third version of the incident, which arose due to a response in cross-examination by one of the main prosecution witnesses. The appellant submitted that the third version of events arose out of one of the main witnesses' reply to counsel's question in cross-examination. The appellant posited that the conviction was unsafe, as the trial judge did not expressly extract this third version of the incident to determine whether self-defense arose. The lead judgment found that prior to the witness's single inconsistent response during cross-examination, there were 5 other times during examination in chief and cross-examination, when the same witness would have given a consistent account of the sequence of events. In those 5 instances, the witness said that the deceased was shot first before he chopped the accused. The lead judgment also found that the witness's misstatement was corrected in re-examination. Given the effect of re-examination, the statement did not form part of the evidence as such, and there was no third version of events. The lead judgment also reinforced that there was no obligation on the trial judge to single out the third version of events and express that she rejected it. Generally, a judge sitting alone is not under an obligation to expressly spell out every step of the reasoning. Justice Anderson, in his concurring judgment, emphasized a discrete reason for the dismissal of this appeal based on directions to be given by judges sitting in judge-alone trials. Justice Anderson pointed out that the trial judge was not under an obligation to extract a third version of the incident and subject it to a discrete recount and analysis. A judge sitting alone has some leeway regarding directions, and as such, it is not necessary for a judge to direct themselves on every possible variation of the facts, contrary to those found to be true. Accordingly, the appeal was dismissed and the decision of the Court of Appeal of Belize was upheld. Thank you, President.
Thank you, Justice Barrow. Just to remind us, as I think intimated by Justice Barrow, again, that this is a summary of the judgment. It's not an authoritative statement of the judgment. That authoritative statement is to be found only in the judgment, and the summary ought not to be cited as authoritative of the reasons of the court. Counsel, is there anything you wish to say?
No, please, Your Honor. Much obliged for the court's decision.
Thank you.
Nothing on this side, Your Honors, except that it was a pleasure appearing before the panel in Trinidad after so many years.
Yes, the pleasure is reciprocated in respect of both counsel, of course. Thank you so much. Madam Deputy Registrar, would you bring these proceedings to an end, please?
Yes, Judge. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnatley. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Burgess. And thank you, Mr. Justice Javada. Thank you, Counsel. And a thank you to the staff of the Caribbean Court of Justice. Do have yourselves a wonderful and safe weekend. This court now stands adjourned. Good day to all. Thank you.
Obliged.